everything that we went through, but the sum and substance of it, there's at least a record of the court's decision regarding bond in this case. This case involves allegedly the entry by this defendant into someone else's home. People versus Scales.
Assistant Public Defender Jay Bellinger on behalf of Ms. Scales, who stands by my side. Ms. Scales, can you please state your name again for the record?
Carla Shundale Scales.
All right, Ms. Hughes, I don't know how much of what we went through you want to place on the record.
I appreciate you giving me the opportunity. What I would like to place on the record is that at the time that I charged this, I requested $250,000 after the other moving a request today for the reasons that I mentioned at the time. If at any point she is released from custody, I am requesting a home confinement tether. Thank you.
All right, thank you.
Your Honor, I would just add that I would just ask for a reduce. I don't know that 250,000 is necessary in this case. My client is willing and capable of doing home confinement. Now, home is in contest, as I've been made aware by the court. However, it is my understanding that mom has a place to go. Mom has a place that she can stay. I don't currently know where that address is at. Mom had to leave to go pick up my client's daughter from school. She does have a 20-year-old and a 17-year-old whom she resides with, whom she takes care of. Her son helps her with regard to the finances. Her daughter, like as I said, is 17, still in high school. I just would like an opportunity for my client to be able to get out. I don't know that 250,000 is necessary, although I do understand the court's concern when it comes to there being a weapon in question out in the sphere.
Right. Well, and again, I don't want to reiterate everything that we went through, but the sum and substance of it, there's at least a record of the court's decision regarding bond in this case. This case involves allegedly the entry by this defendant into someone else's home. Critical to that is the changing of the locks on that home that belonged to somebody else. I am also to understand that she was in possession of a deed to that home, a license which indicated that address, and voter registration at that address. As it turns out, at least the investigation has revealed that address is not hers. It belongs to two other individuals.
Those are the allegations, yes.
Right. That would have occurred basically December 25th through the 30th, but somewhere around that area of 2023, the end of December 2023. The court was then informed that there was another address on Panama that the defendant, that was her address. Going through the court records, because that's this court's jurisdiction for summary proceedings or landlord tenant, a judgment evicting this defendant was issued by myself in mid-December of 2023. That would have made the writ or order of eviction date the end of 2023, approximately that same time that she allegedly entered these other individuals' home and sort of set up domicile there. So that's curious enough. Trying to figure out under what terms and what conditions the court would feel comfortable releasing the defendant, because these allegations are rather serious, that because these folks' home, these allegations, was transformed. There is approximately, these allegations, about $11,000 plus of property missing from these premises while these people were on vacation or just had left their home for a moment. There's also a weapon that is missing. The defendant is there and doesn't seem to be able, or doesn't seem to, under color of any right, have any ability to to be in those premises. So there is this other address, Roundtree Boulevard in Ypsilanti Township, which is the address which is in the court file, which the court could see fit to potentially tether. Initially thought that I could tether this individual to that address, that there's something that we could do with that address to keep the public safe. I'm then informed, so that, again, the record's clear, that on March 11th of this year, that the defendant, although contacting the police, returned to the address in Ann Arbor, which was the address where she had moved into again. When the police and everybody had told her to stay away from that address, she went back there. That's March 11th. That the dates are important. And I informed counsel that I then went back to look at, or just the curiosity for the court standpoint as to why she was returning to that address if she had this other address in Roundtree Boulevard, Ypsilanti Township. Turns out when we look up the court cases in the 14B jurisdiction where Roundtree would be, that she is indeed being evicted from that Roundtree premises, which fits factually into what she had previously done. When there's an eviction, she goes to this other house. There's now this other eviction, she's showing back up. So I don't know where this defendant would go. I don't know where she is even supposed to be. Counsel did inform me upon the court's question that the Roundtree address she had been residing at for approximately 5 years. That fits with various court records that that's her address. But her current driver's license is for the Panama Street address. Moreover, the Panama address, the license was issued to her after she had been evicted from those premises. So I'm not clear what's going on. That means she would have had to present herself to the Secretary of State for the issuance of that driver's license, knowing that she no longer resides at that address. And she's at another address. And then there's this other address on Roundtree. So again, I don't know, even if I were, I'm disinclined to, at this point, give a tether because I don't know where she is supposed to be.
I understand, Your Honor. Thank you, Your Honor. I did want to inform the court as well, Your Honor, aside from bond, that I've talked to my client, I've talked to my client's mother, I've talked to prosecution, we'll be submitting an evaluation for competency to this court as soon as possible. I can have that done and submitted by tomorrow so that we can start the proceedings on that. And I can always file a motion as I know to do if I find out a place for her to go. Should this court, it doesn't sound like this court is going to do anything but remand her at this point. I understand the court's position on that. I would again just renew my request for something a little more palatable than 250,000. I don't know that that is necessary in this case, although I do understand the court's concerns as I stated.
Maybe I wouldn't consider the people's request in terms of its monetary amount necessary if I didn't have the incident from March 11th.
Okay.
I have very serious concern, and well, the incident from March 11th where she goes back to the premises, the missing firearm, all of those things are of grave concern to the court and I believe pose a danger to the public. So I am going to set the defendant's bond in an amount of 250,000 cash surety. I would, part of the The other concern, counsel, that I have is that the defendant has ties, as I see them, to other states. I see she has ties to Virginia and Tennessee. And my understanding is that her mother is up here visiting.
Yes, Your Honor.
From what state?
Virginia, Your Honor.
The other condition is, at least at this point, is GPS tether, home confinement prior to release. So if she were able to post this, she'd have to be on a GPS tether for home confinement. Our difficulty at this point is I don't know where that is.
Okay.
All right. And I'll leave it there. I'll set a competency hearing in this matter. 90 days out.
July 2nd at 9 a.m.
I've set a competency hearing for July 2nd, 2024, 9 a.m. Court calls case People versus Devonathan Gibson.
Assistant prosecuting attorney for the people.
Brown appearing on behalf of Mr. Gibson, Your Honor.
State your name, sir.
Devonathan Gibson. Good morning, Your Honor.
Good morning, sir.
Your Honor, I'm requesting an adjournment in the case. May I address bond?
Yes, he's held on some. Are you
Well-
held on my other case or not?
He's going to see Judge Valvo this afternoon.
Okay,
And he also has 2 misdemeanor traffic matters where he's scheduled for court in front of Judge Flushhour on either Monday or Tuesday where I represent him.
okay,
So basically, Your Honor, he has a medical condition which requires a CPAP machine. He tells me that the CPAP machine has been on recall and therefore he's not breathing properly in his sleep. He has a 17-year-old son that he is primary custody of, and he's trying to make sure that his son is taken care of. He's employed or has a job at DeBello's Sub, which opens next week, Your Honor. He also has diabetes and high blood pressure, and he needs his medications and his health concerns addressed. So I'm asking the court to consider a personal recognizance bond. These are old retail fraud cases.
any response from the group?
You're familiar with him because he's on your district court docket. Oh,
Yeah.
no, there was an OWI case, a high BAC case that he has. I don't know if that's before Your Honor.
I thought that didn't he approve for Wednesday? Huh? Yeah, I saw him yesterday. What did, and then,
Your Honor, just to let you know, when I reviewed his files for our open cases, I see 4 other matters pending in the district courts. Mr. Brown's referenced at least a couple of them. They're all retail frauds except for that high BAC that I just mentioned.
see, what did I put it?
I'm sorry, there's also one deal.
Hold on.
There's a malicious destruction with us.
Yes,
Is that a separate case or the same case?
it's 7.
So he has 2 cases before me.
A retail fraud, it's another case.
So he has 3 cases before me.
Yes.
Your Honor, he turned himself in 2 Sundays ago, so he missed Easter Sunday dinner with his family. He's got 3 kids in the household.
Okay. What are his bonds on my case? That's what I thought. He has $50 bonds. I think
I think
the OWI, I may not have.
they're all 50. Actually.
They're all of his bonds on the other case are $50 cash surety.
But this one isn't.
Correct.
So that's why I'm trying to get it down. You know me.
Your Honor,
That wasn't
the
helpful.
only concern is just if that OWI is your case, then I'm not concerned. So if you do reduce the bond, I'm sure there'll be appropriate conditions in place for
Yeah,
him.
did we put him on a scram or soberly anytime? I'm sure I did or should have. You don't see it in there. Okay. That it was a high BSC. That would be unusual if I didn't, but I don't know if the arraignment came before me or the magistrate.
It didn't, the arraignment was not before you.
So, all right. Here's what I will do on his case. I'll release him. Well, I'll set this bond at I'll set it at the same amount,
$50?
$50 cash surety on this one also. On the condition that if I didn't order it, he's to get himself placed on a scram tether
Okay.
through community correction. Do
So.
you recall me ordering that?
put
or the
you on
magistrate
damn
ordering?
presentation, you ain't drinking?
I want to scram on him. Huh?
Okay.
on my misdemeanor, I want to scram on him. Okay,
No
So-
objection.
so you understand what's gonna happen? Yeah, I mean, if you post these, then you need to have a scram, you need to get over to community corrections, get a scram tether put on.
Sometimes they put it on them before they cut them loose. Sometimes.
Yes, that's correct. All right. And what date did I give him?
You did not give one.
All right. So then I'll set this. Are you likely to post all of these or what do you? I mean, I was gonna give you the 25th, but if you want me to give the 18th, I will.
I'm hoping to post, yes.
Which date do you want, Mr. Brown?
The earlier date, just in case.
April 18th, 2024, 9 a.m.
So you got $50 bond on it.
Right. Part of that is that you got to get yourself, if you post it, you got to get yourself over there
I understand.
for that. All right. All right. Thank you.
Thank you.
Court calls case People versus Brandon Scott.
Andrew Bannon, Assistant Public Defender, written on behalf of Mr. Scott. Mr. Scott, could you please?
Brandon Martini Scott.
You know, there's two things. We are respectfully requesting and asking permission to address my client's bond.
You have all the discover. People had the witnesses available to sustain. Preliminary examination will be set in person, April 16th, 2024, 9 a.m. before Judge Balvo.
Thank you, Your Honor.
Yes, as the bond.
Yes, sir. My client is currently held on a $25,000 bond case. He is asking for the 10% privilege. He understands. I talked to him this morning specifically about the bond issue. He understands he has to come to court regardless if he posts, but also certainly will have a financial incentive if you allow him to post the 10%. He does have a job, reports to me full-time in a restaurant. He does stay at the Delana Center, but also has a case manager through Delana's, which is assisting him with Section 8 paperwork. He has several children, parenting time, and wishes to get out for several reasons, obviously, to continue to communicate with us about his case, but also to get back to work.
Response.
Your Honor, the defendant requested a motion to capture the bond. The defendant, at the time that he committed these offenses, was out on bond in a domestic violence case against the same victim. That is a township case. I do not have access to the case files. Probably wasn't said what that is about at this time. However, on this date, despite the no-contact order, the defendant continued to reside with the victim. It appears they were living at a Victory Inn motel, and at the Victory Inn, the defendant was consuming heavy amounts of alcohol, again, while out on bond in the domestic violence case. And he strangled her. He put both hands around her neck and he strangled her for, as she perceived it, a few minutes. He held her down on the bed. She was not able to breathe. She reported to the police that she feared for her life. She described that the defendant was on top of her, grunting and breathing while he strangled her. Your Honor, I'm frankly requesting the $100,000 cash surety given that he was out on bond in the domestic violence case and the lethality issues that exist here. Thank you.
He was out on bond. That's what I want to make sure. He was out on bond on a DV.
He is being, what I can tell you that I know for sure is he is currently being held on a 14B case for an alleged bond violation with the next court date of April 25th.
But is that a DV case?
Don't say anything about the case, but is that a DV
That
case
is
in
the domestic
Judge
violence
Washington's
case.
court?
And that's his
That's-
bond.
I'm not sure, Your Honor.
I can see that as the same township number. It's 23T00817. That is the full up in JS to confirm that's for township.
Right, that's IFC. And
That is the case number.
it is. It's a DV. So he was out on bond. This happened on a DV and he ends up with only a $25,000 cash bond.
Correct, but she's not going to be able to post, even if you leave it. with-
I understand, but I think that the bond is set in this case, given the circumstances inappropriate. Court finding an abuse of discretion is going to increase the defendant's bond to $75,000 cash surety. And then you'll see Judge Balvo. Oh, okay. Court calls case People versus Jeffrey Holloway or Jerry Holloway. Why would you put F there?
Alex Warren Green on behalf of Mr. Holloway.
Oh, on ours.
Jerry Holloway.
We do.
We're asking for a preliminary examination in this matter.
You have all discovery?
We do.
Do people have their witnesses available to 16?
Honor, may I address bond?
Yeah, sure.
Thank you. Your Honor, a community corrections warrant was issued in this matter.
I know, I did it.
And that was because Mr. Holloway did not report to community corrections.
Correct. He did not at all.
And he did yesterday, hence his appearance in custody this morning. So
So he appeared at community corrections,
that's right. He went to community corrections and was arrested. On the
albeit
outside
late.
warrant. It was late. Yes.
It was hugely late. And then I had already issued the warrant. And so they took him in.
Right.
Okay,
And
go
Your
ahead.
Honor, I had an opportunity to review Mr. Holloway's bond petition with him. And I believe Mr. Holloway, if he didn't know before, certainly knows now that he needs to enroll in community corrections if he's released from custody and continue testing as required by his bond.
Any response from the people?
I'm just reviewing his bond conditions. I requested a 25,000 cash surety. The magistrate gave him a 10,000, 10%. I did request home confinement or a GPS other than the alternative. I don't see from my notes that either of those were ordered. Since he was suspended, the court is inclined to release him if regarding the community corrections issue. At the very minimum, a GPS tether would be appropriate. This is strangulation case.
Well, where would he go?
I don't know where he would go because the home is where his wife, the victim, resides, and that's the hot zone I would request.
Your Honor, Mr. Holloway was residing with his daughter. It's his daughter, not the daughter of the complaining witness. So that person,
Where?
what city is that in?
It's in Brownstown.
It's in Brownstown, Your Honor.
Did we even know that?
Yes, I called right after I was released and notified the courts where I was going to be staying. It was on my paper. The woman that took care of the release said, call this number on the paper. Tomorrow morning, tell them where your new address
We
is.
have the Brownstown. Okay. Why didn't he go to community corrections?
Your Honor, Mr. Holloway tells me he was not clear on what his bond requirements
He had the
were.
paperwork to call, but it wasn't clear that he was supposed to go
It
to
didn't.
community corrections?
I asked when I was released about what I did for the drug alcohol screening. And the woman that was taking care of it said, just listen to me, call this number, give them your information to contact you and we'll contact you.
But you had the paper to call him.
It just said to call to give update my information for address. And when I called, person said, you're all set, somebody will contact you. So I was waiting for somebody to call me so I could get in.
I'll set his preliminary examination, April 16, 2024, 9 a.m. That's before Judge Valvo. Don't know if I already said it. Regarding his bond, I'll set his bond at $25,000, 10%. We'll give a 10% privilege, but he needs to be on a GPS home confinement tether if released prior to his release. Court calls case People versus Casey Gepner.
Good morning, Your Honor. William Amadeo, P76194, on behalf of Casey Gepner. Okay. Casey, please state your name for Judge Simpson. His staff and prosecutor will bring that with you.
I'm Casey Gepner.
Thank you.
Your Honor, at this time, I had a goal of waiving both preliminary examinations. That's not going to happen. Wayne County's forced me to do
Both preliminary.
he has Wayne and Washtenaw.
Okay, I don't
Yeah,
care about
that's
the Wayne, but go ahead.
Okay. Well, Wayne's forced me to run the prelim, so I'm going to have to run that April 19th
Oh, they're in their case.
in their case. And therefore, I'm going to have to run it here. It'd be malpractice. I don't like having 13-year-olds testify at prelims, but I'm going to have no choice in this matter. I did ask for a universal waiver. I was just denied that. So I'm going to ask for a PCC. The Washtenaw will waive, Wayne will not.
Oh, that's the universal.
That's universal.
Yeah, Washington's special. Anyway, go ahead.
With that being said, I'm going to ask for a PCC after April 19th, so I'll know where I stand with the preliminary examination, Wayne, and we'll take it from there.
So a little bitter. So you had that April 19, and so April 25th on this one, would that work? For
That would work,
PCC?
Judge. That works. Thank you.
Probable cause conference, April 25th, 2024. 9 a.m. Bond continue.
Right, I'm gonna address just one bond issue that I had discussed previously with Mr. Amadeo.
Oh, sure.
Okay. I was informed by AAPD that At arraignment, the defendant was ordered to turn over any weapons that had been in his possession in the house he was living. My understanding is that he told the court he had 2 handguns, but AAPD returned to the house and there were additional guns at the house. So I just want to ensure that all weapons at the house, in case the defendant, for whatever reason, can post. I think his bond was denied on the Wayne County case. The 2 cases are the same victim, just incidents in different counties.
Got it.
And Judge, at this point, he's been denied bond in Wayne. I'm going to address that in Wayne. With that being stated, I did speak to Prosecutor Willenbrink. I do believe there were some other guns in the house. I did offer to assist AAPD and get whatever is out of the house. I have not been to the house yet. I certainly take her at her word. If I could help in any way, we'll get them out of there. We don't want to hold the guns in the house.
Well, so AAPD discovered there were other guns.
Right.
Was that by going into the house?
Yes.
So they just did not take the guns?
That's my understanding. They were there with CPS to speak to other individuals at the house.
And
That's when they saw weapons.
So did they take the 2 handguns that he acknowledged?
I think that those were surrendered.
And so there were other weapons that were in the house.
Correct.
And Judge, we consent. If AAPD wanted to take it, we had no problem with that whatsoever.
Well, with the taking of the weapon, how many other guns do we have?
AAPD made me aware of 2 long weapons in the house, but I'm not aware if there are additional ones.
Judge, I think there's 4 total in addition to the 2. I've been dealing with Mr. Gepner's mother on this matter because she went over to the house. She knew where everything was located, but I did think he was going to get bonded after I got him bond here. I think there's 6 total and AAPD has 2 right now. So I'd certainly hand over the other 4. I also don't want to misrepresent anything to you or the prosecutor. If there were more in the house, they could have any gun there with my cooperation. I just don't want to speak for exactly how many there are, but I believe there's 4 in remainder.
Going to order that all the firearms present in the defendant's home are to be surrendered to the Andover Police Department. I prefer that I have a written order to that effect so that the officers have a written order that they can take them.
Okay.
I've written it on the Carol, but I think they prefer a written order.
Thank you.
All right. What calls the case? People versus Thomas Sebastian.
Alex Warren, green on behalf of Mr. Vasher. Mr. Vasher, state your name.
Thomas Sebastian. All right. What are we doing?
Your Honor, we're asking for a preliminary examination.
Discovery is complete.
Discovery is complete, Your Honor, and I'd ask for a brief moment to address bond.
The people have their witnesses available the 16th. Preliminary examination in person, April 16th, 2024, 9 a.m. before Judge Valvo. Esteban.
Your Honor, Mr. Vasher is held with a $30,000 bond. In this case, he's held on 5 circuit court matters. Bond is denied in all of those. It's my understanding that there is a sentencing agreement in circuit court which would permit him a release to treatment. So I'm asking the court to consider allowing a release to treatment on this matter.
So there's a release to treatment on the ones where his bond's been denied.
There has been a Cobb's agreement negotiated in circuit court.
So when is that going to go into effect, however?
I believe it is next pretrial.
Which is when?
Do you go to, I think he goes to circuit court this afternoon at 1:30.
You just want this one to read release to treatment.
Yes, Your Honor, so that if he gets a release to treatment in circuit court, that this would not hold him up from going.
Any objection from the people?
So many reservations given. So yes, one is I don't see that in the circuit court files. I just see bond denied. I see that he failed to appear in his circuit court files back in August 2023. And he was in bench warrant status all the way until February of 2024. And at that point, a complete remand was placed on him. And it has continued. So I don't see anything in the file that allows his release for treatment. But then in addition to that, we have this new strangulation case, even for somebody who has failed to appear in the past. I just have great reservations about that.
Your Honor, I spoke with Mr. Vasher's circuit court attorneys this morning, and they informed me that a Cobb's agreement has been negotiated in that matter, at which point he enters the plea, he would be permitted.
But I don't have the plea entered. Yeah,
That's right.
okay, so that plea may be entered this afternoon, may not be, right? If it's not, then my file's gonna read release to treatment, but his won't, but the others won't.
I'm willing to.
That's correct. Yes, if he does not enter a plea today, those
Right.
will
And
remain
I'm-
bond denied.
Can I say something?
You keep trying to, so there, go ahead.
I never missed a court date except for while I was in the treatment. That was why I ran when I left and I didn't come back is because I had a warrant for my arrest. And, you know, an addict honestly does not turn himself in. I was using. So I had a warrant for my arrest. I did not come in. The warrant was already issued for my arrest because I was in treatment and missed a court. I'm going to a Chance for Life treatment, which is a year-long program. And it's a good one, and I'm willing to do whatever I have to do.
We're trying to get him back into treatment, Your Honor.
I know. I'm not going to grant your request. I'm going to continue his bond. If that does change, then certainly you can get to Judge Valvo for that release if it's all set up to go into this treatment. I don't think anybody's going to stand in the way of that, but I think I'd like to see that set up
Understood. Thank you.
prior to that happening. Thank you.
Assistant Public Defender Jay Bonder on behalf of Ms. Johnson who approached us. And can you state your name for the record?
Teresa Johnson.
And Your Honor, we are executing a waiver of the examination right now.
Ma'am, you wish to waive your right to a preliminary examination?
Yes, sir.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
All right. And you understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Thank you.
You understand that?
I think so.
Well, I got to make sure
I'll
you
try.
do.
We're trying. Okay.
Do you understand that you could have a preliminary exam? Okay. You understand that you could have a preliminary examination at which the people would put on witnesses and the court would rule by a standard of probable cause whether or not there was a crime committed and whether or not you committed that crime. You understand that that's what the hearing would be?
Yes, sir, I do.
All right. What I understand you're doing today is that you're waiving that hearing, meaning that hearing won't happen, and
Okay.
you're agreeing to be bound over to circuit court to resolve the matter there.
Okay,
Is that what you want to do?
sure.
Well,
Oh, yes. No, I don't.
You don't want to do it?
you don't know what, okay, it's okay. I mean, that's one of the reasons I go through it.
Okay,
Is, so you're not, let me say it this way, and if I'm wrong, tell me, okay?
okay.
And that is that you're just not sure whether or not that's what you want to do, right? At this
I'm-
moment.
Not sure at this moment.
Yeah, okay, and so you need further time to talk to your attorney about that.
Correct.
Okay, very good. Thank you. Thank you
you.
for letting me know that.
You're welcome.
So is there anything else holding her?
No.
Not, well, Your Honor, it's not at this time, Your Honor, is my understanding. It's my understanding that there is a warrant there is a warrant review for another case, but
Another felony?
it's my understanding.
Yes, he's
Got it. Okay, let me do this then. I'm gonna put this over to the 18th. I'm gonna go 2 weeks out.
Okay.
Thank you.
April 18, 2024, 9 AM. All right, and bond
you.
will continue on this case. All right,
Okay.
Okay.
thank you.
Thank you, Your Honor.
I love you, sir.
Pardon?
Take care, yes.
Okay, thank you.
Thank you.
Let's call the case of the people versus Donald Pope.
Jesse Green, Special Assistant Attorney General, Your Honor, here on behalf of the people.
Good afternoon.
First Assistant Public Defender Quinn Anderson with and on behalf of Mr. Pope. Mr. Pope, can you state your name, please?
Mr.
Donald
Pope,
Curtis Pope.
do you have a camera, sir?
Yes, I do, but I don't know how to use it.
All right, what are we doing on this?
Your Honor, this is a failure to pay child support case. He did post a bond in the amount of $6,713. I submitted an order to the court to have those funds transferred over to the friend of the court case.
Yes.
He will be doing a waiver. There's an offer for delayed sentence upon him making some payments. So he's going to waive up to circuit court to resolve the matter.
He's gonna waive?
Yes,
All right, so I've signed the order.
thank you.
And Mr. Pope,
Yes, Your Honor.
you understand that you're waiving your right to have a preliminary examination?
Yes, Your Honor.
And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
And you do understand you will not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
All right, people also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Thank you, Your Honor. We received a copy of the information. Waive its formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
30 before Judge Slay Monday.
May 13th, 2024, 1:30 before Slay Monday.
May 13th. Okay.
Okay,
Thank you.
all right, thank you. Bond will continue.
I got a question, Your Honor. Will I
Yes,
get
sir.
this email? Will I get this email to me
Pardon?
on information? Will I get all this information emailed to me about the court date?
If you're waiting on me to do it, then no.
I'm gonna mail you a
But-
notice. I'm
but-
gonna mail you a notice this
But
afternoon.
your attorney will be more than happy to communicate with you.
Okay, sounds good. Thank you.
All right, thank you, sir.
Thank you, Your
Have a
Honor.
good one.
Court calls the case People versus Maurice Jones. Where's Stacy?
Again, Senior Assistant Public Defender representing Mr. Jones. Would you please state your name for the record?
Maurice Jones. Thank you.
One piece of information I just.
Sure.
Your Honor, at this time, there are no offers. We are requesting a preliminary examination date.
All right. Hold it. Is this an additional? We didn't have an additional violation. No, what happened is it was since 28, give him credit for 21 on this violation, but I don't know. It's still showing as denied. Got it. In our system.
Yes.
So our system is showing his bond is denied. However, I understand how that happened. That came from the warrant and then the sentence I gave him on the violation.
I see.
So I'm going to reinstate his previous bond,
Thank you.
which I believe originally was a 5,000 PR. Of course it was.
Is the court in receipt of the progress report dated the second, April 2nd?
I am, and that's one of the things we need to address. Hey, do you have that?
Yes, Your Honor.
Why are you drinking?
Your Honor, he has no objection to Your Honor placing an alcohol tether of some sort on him so that you could more effectively monitor that. So that is our request. It's prepared to go across to corrections and get one today. Is that right, sir?
On everything.
He is also scheduled today for his assessment that had been previously scheduled for his matter before Judge Freshour. I believe he said that's today at 1:00 p.m. So he would go get the alcohol tether and also go to his assessment,
And you wish this set for
a preliminary examination.
preliminary examination will be set April 16th, 2024, 9 a.m. before Judge Freshour in person. The defendant is also, I'm going to sign an order, you're to report over to community corrections to place him on a scram tether. You understand that?
Yes.
Calls case People versus Gary People.
People, Bob Brown, on behalf of Mr. Peoples, Your Honor.
Your name?
Your Honor, may I call a witness, Ms. Ariane Connor? I'd like to address bond.
Say again.
May I call a witness briefly to address bond? I want to modify bond to allow contact, and she's here in the courtroom.
I don't know. I need a witness at this point. What is the modification request?
Consensual contact between my client and the complaining witness, Ms. Carter, and she's here. The court wants to hear from her.
I know. I got that. Is there an objection from the people?
There is, Your Honor, and just for recollection, Ms. Barroso handled this when this was last up on March 21st, and concerns were brought to the court about, concerns were brought to the court regarding jail calls after the defendant had been initially arrested in the wrong time of arraignment. There were multiple jail calls that may result in a forfeiture by wrongdoing motion. The nature of those calls were to more or less not talk to the police, not assist in prosecution. Why did you do this to me? Not summarizing, but those sorts of things. So I absolutely would be objecting to any modification of the contact order. It's my understanding Mr. Peoples wishes to set this for an exam.
That's correct. We wish to set it for an exam, but she's here. She was here the last time. And I didn't get an opportunity to raise the issue then with her testimony. Court had any question as to her state or lack thereof.
Discovery is complete.
Yes, Your Honor.
People would have their witnesses available on the 16th. Preliminary examination in this matter will be set April 16th, 2024, 9 a.m. That's before Judge Valvo. With regard, since that's just a few days out, with regard to any change in the status, I'm gonna let the preliminary examination happen since it's so soon. And then let Judge Valvo, leave that call to Judge Valvo.
Yes, Your Honor.
Bond will continue with its conditions at this point.